Hello, everyone. How are you doing? How is everything going? This is Lawyers Infohub, and I'm your host in this platform. Uh, we talk about law practice, we share legal content, topics, we share experiences to help you in your practice, to help you in your growth as a lawyer. Share law content that help lawyers, law students, anyone interested in law. That is what Lawyers Infohub is all about. If you're not subscribed to this channel, please hit the subscribe button and share this video. So today we're looking at the housekeeping job of a counsel. When we hear the word housekeeping, most people do not understand what the word means. It's a sentence that depicts the work of a counsel in ensuring that you do your own part, in handling any matter you're doing to ensure that there is no delay, that you do not cause delay in the dispensation of justice. A lawyer owes a duty to the court. He owes a duty to the bar. He owes a duty to his client, to ensure that in carrying out his work, in carrying out his job, in ensuring that matters are heard, in doing his cases, he does not cause delay in any form. There are things lawyers are expected to do. As a counsel, you need to ensure that your processes are before the courts. For example, you need to ensure that if you're supposed to serve the other party, you have served the other party. You need to follow up on bailiffs to ensure that, because of the nature of the system we see ourselves here in this part of the country, you need to follow up. You need to ensure that, for example, that the bailiff has served your process and there is proof of service in the court file. These are things that can delay a matter. But when, as a counsel, you must be diligent in handling your matter. You must ensure that the process, for example, you're to be going to court to argue a motion. Now you ask yourself, this motion, has it been served? If yes, was it served personally? Was it served through a bailiff? It was served personally. Have you prepared the affidavit of service so that the court to be convinced that the other party has been served? Peradventure, that other party does not show up in court. Because if the other party does not show up in court and the court is not convinced that that other party has received your motion, hearing that motion means the motion was heard, to the detriment of the other counsel who will come tomorrow to file an objection on, that his right to fair hearing was not, was violated or breached. So we have to do all that is within our power as counsels to ensure that our matters are moving forward. A lot of people complain, we've been on this matter for 10 years, we've been on this matter for 6 years. In as much as the courts, there are challenges in this part of the world in terms of uh, there might be sometimes force majeure, act of God issues, a strike, one problem or the other, but that might make a court not to sit, or might make courts to, to stop for some time. Or we have the issue of the annual vacation. There are a lot of challenges. There are a lot of challenges, and matters are not concluded on a day and one day. So adjournments happen. But now the adjournment, when it happened, is it because a counsel didn't do what it's supposed to do? Or did the adjournment happen because, parties have done what they're supposed to do and they are adjourning to move to the next step? Now, in law school, we're taught about how to the trial plan, how to move, how to prepare for your matter. Many people, when they come into practice, they forget this thing. When you have a matter, what is your plan? What is your strategy? Have you planned out how this matter will go? Have you foreseen those circumstances that might hinder the smooth, conclusion of the matter, or the speedy conclusion of your matter? What are you doing to stop those speed bumps? What are you doing to, ameliorate those circumstances, or to stop, or to quell, or to let's say reduce those interferences, those interjections that will stop your matter from moving very fast? We've had people conclude appeals within 2 years, within 1 year. We've had people conclude matters in 2 years. We say, that judge is very fast. Because, yes, that judge is slow. It's not that the judge is slow. Sometimes counsels contribute to, their matters not moving forward. When you've not done what you're supposed to do, you came to court, you're supposed to serve, you didn't serve, and the court has said, okay, counsel, go and serve. It was adjourned because of non-service. You come back 2 months' time, the same issue, it shows the lawyer is not diligent. So sometimes when there are judges who do not take, all these lapses, they do not take all these excuses. So people say things, damn them, that judge is harsh, that judge it doesn't is not friendly, because the judge does not admit, does not allow stories. If you're supposed to do something, you do it. There are judges that before they give you trial date, they will ask the counsel, my trial date dot with. Are you sure you're ready for trial? Because if you come on the day of trial and you're giving excuses, you will be in court to give costs, for wasting the time of the court. So as a counsel, you must know how to, do your housekeeping. You have to, and your own part, have you done the needful? Have you done the needful? Have you said your to do trial? Have you ensured that your documents are proper? Are they in the form you can tender them? Are they, for example, you have computer generated documents, and you need to tender them in evidence. What have you done to ensure that there are no back and forth of objections here and there? Now, sometimes you see judges for trial, they say, parties, reconcile your documents, come together. If you have any objection, file a notice of objection. These are ways to, to speed up trial. These are ways to conclude matters on time, rather than going back and forth on a ruling, which each party, if you come together to settle documents, you'll be able to know which ones you need to know which ones you are, objecting, the other counsel is objecting to, and which one that the other party is not objecting to. It streamlines the argument. It streamlines the time the court will have wasted in arguing and arguing and arguing. Now you a counsel, you're filing a matter. I mean, the era of front loading, you withhold some documents. You will not front load them. Now during trial, you're now, you start bringing up documents. That same aspect of surprise that front loading has come to cushion. You're still doing it, but you're not doing your housekeeping well. So as counsel, we must learn this. We must teach the young ones how to prepare for their matters, to ensure the delay is not on their own part. You see people travel all the way, 2 hours journey, 3 hours journey, they fly, spend money, and go to court, and adjournment happens at the instant of another counsel who ought to have done something he failed or neglected or did not do. So we have to encourage the courts, we have to encourage our judges, we need to do what we need to do, to ensure that these matters are concluded within time. Sometimes they'll tell you this judge in your court too, within 1 year you're done, because some judges do not take excuses. If you're not ready, your matter is struck out. Whenever you're ready, you come back. So people term them as very strict. They're not strict, but because they want the work to be done. They don't want you to delay them, because because they have a higher authority they submit to. They need to send in their report. So why waste their time? No matter if it's 4 years, 3 years, nothing is happening, because counsel at one point or the other has delayed the matter, because we don't know what happens tomorrow. So that opportunity we have to be in court, what have you achieved? So people go to court, yes my lord, yes it's for mention, but do you have an application to take? Is there an application? People come to the court without reading their files. Is there an application you need to take? You take. What other steps? Some people even know what not next to do. So these are things we need to learn. These are things, if you have juniors in your chambers, you have friends, teach them. Any opportunity you go to court is a golden opportunity. Don't waste it. Don't waste it. Always strive that your matter move to the next step. Have you cleared your outstanding pending application? Have you filed your CMC forms? Depending on your jurisdiction, have you filed your form 17 and 18? What are you, okay? Have you done that? Okay, is your court, depending on your jurisdiction, is it the trial court? Is it supposed to close the CMC and move it to a trial judge? Is it the judge that, if it's depending on your jurisdiction, you know, is it the one that take the trial? Ask for trial date, move your matter forward. If the other party is not coming for that, you want to prove your case, go ahead and prove your case. If you need to make an application for the matter to be struck at, go what to do. Don't go to court just to clarify. Many people go to court to clarify. They've not done the housekeeping job. They still have things they're supposed to do on their own part. They have not done. And we expect magic to happen. Magic doesn't happen like that. Do your own part. And when it's important to know that when you do your own part, over time it will tell in your practice. It will tell that a counsel is very serious. Judges will know, people will know, like, whenever I'm with that lawyer, she's always on point. When you do your housekeeping very well, even the other counsel on the other side will have no option than to raise up. But eventually, it's kind of counsel that does take things like a basic kind of brain and know that if I don't do anything, this guy might ask for my matter to be struck out. This other counsel is a serious counsel. So when you do your housekeeping very well, it projects you. It shows you know what you're doing. It shows you're very serious. It shows that you know the value and the worth of judicial time. You don't need to waste it. Do all you can on your own, so that at the end of the day, tell yourself that I did well. I did not cause the delay in this matter. I was always there. Sometimes counsel will not be in court. Counsel will not inform the other lawyer. Counsel will not write to the court to say, "Okay, my lord, this is the reason why I'm not in court. Can I suggest this and this?" Then, if you need to have someone to send, send. Though there are circumstances, maybe you don't have someone to send and all that. But I know lawyers who at no cost do they go for an adjournment letter. They will always send someone to appear. It still shows the respect they have for the court, because sometimes it's not even easy to get a date. I now get there are lots and lots of cases. So anytime your case comes up, go to court with this temerity, go to court satisfied that you've done your housekeeping well, you've done your job well, you are satisfied yourself that all you need to do, you have done. So, my friends, this is just something that has been, in my mind, and I feel I should just talk about it. But many people, you just say, "My lord, take a moment to do the needful." You end up the next adjournment, they've not done the needful. So we must help. A lot of people complain, the matters are taking time, clients are complaining, but sometimes lawyers have not done what they need to do. So ask yourself today, am I doing the right thing? Have I done my housekeeping well? Have I done all I should do in this matter to ensure that there is no delay? Even if there is delay, let it not be from you, who is a smart lawyer. Let it not be from you, who is a diligent lawyer. Let it not be from you, who is doing well. So, friends, if you've not subscribed to this channel, hit the subscribe button, share this video. And I know today we've learned about housekeeping as counsel. Let's do our duties. Let's do the in-house duty. Let's do the housekeeping well. And it's when we do it well, it shows when we go out. It shows, when we are out there, that we have done our own part. Then the court will do their own part. So do take care of yourself and stay safe. Take care.